Most significant case regarding the Second Amendment in more than a decade.
So another unanimous ruling from the Supreme Court.
We have breaking news. The Supreme Court has made a decision on the first major Second Amendment case in decades.
Members of the Senate are focusing on gun rights.
The United States Supreme Court came out with a unanimous ruling.
Now, this is the most significant Second Amendment ruling in more than a decade.
All right, we've got this breaking news just coming into our newsroom right now.
Over the future of gun control.
Second Amendment Preservation Act, often referred to as SAPA.
Missouri gun law now considered unconstitutional, but a federal judge's ruling today is likely not the end of the legal battle.
The federal government passes a law that says you cannot have an AR-15. Local law enforcement cannot help enforce that law.
It's a case that legal experts will be watching closely.
Passed in 2021, it may seem to only support the Second Amendment on its face, declaring as invalid all federal laws that infringe on the right to bear arms.
Justice Sotomayor stood alone. 8 of her colleagues had just delivered a legal earthquake that the Department of Justice never saw coming. In an emergency ruling that took most legal experts by surprise, the Supreme Court effectively told the federal government something it desperately didn't want to hear. You cannot force states to be your enforcement arm for gun control. This wasn't a full trial. This wasn't a lengthy opinion spanning hundreds of pages. This was a swift, decisive strike that dismantled the DOJ's entire legal strategy in one motion, and the implications reach far beyond Missouri, the state at the center of this constitutional showdown. The silent legal war between state sovereignty and federal gun control just ended with a thunderous ruling. But what actually happened, and why should every gun owner in America pay attention, even if they don't live in Missouri? In 2021, Missouri passed one of the boldest firearm protection laws in recent history, the Second Amendment Preservation Act, commonly known as SAPA. The law was designed to prevent state and local officials from enforcing federal gun regulations that Missouri deemed unconstitutional. Critics called it radical nullification. Supporters called it essential protection against federal overreach. Here's what SAPA actually does. It forbids Missouri state agencies from assisting in the enforcement of federal gun laws that the state considers violations of the Second Amendment. It allows private citizens to sue any agency that cooperates with federal gun enforcement beyond constitutional limits. And it declares that Missouri's legislature has no obligation to dedicate state resources to implementing federal firearms policies. The law sparked immediate controversy. The Biden administration's Department of Justice filed suit claiming SAPA violated the Supremacy Clause of the Constitution, the provision that establishes federal law as supreme over state law when there's a conflict. The DOJ's argument was straightforward. Missouri cannot simply refuse to recognize federal law. Federal gun regulations apply nationwide, and states must accept that authority. Missouri's counter-argument was equally direct. Accepting federal law is not the same as enforcing it. The Constitution may make federal law supreme, but it does not require states to serve as federal enforcement agents. Missouri isn't nullifying federal law, it's simply refusing to help implement it. The legal principle behind Missouri's defense is called the anti-commandeering doctrine. This constitutional principle says the federal government cannot force state officials to enforce federal laws. It has deep roots in Supreme Court precedent, established definitively in the 1997 case Prince v. United States. The Prince decision involved federal background check requirements that attempted to compel state law enforcement to conduct checks for gun purchases. The Supreme Court ruled that while Congress can regulate firearms under its constitutional powers, it cannot require state officers to administer that regulation. States have sovereignty over their own resources and personnel. The federal government must enforce its own laws with its own agents. Missouri built SAPA on this foundation. The state wasn't claiming federal gun laws don't exist or don't apply. It was simply saying, if you want to enforce federal gun laws in Missouri, send your own agents. Don't demand that our state police, our county sheriffs, or our local officers do your work for you. The DOJ took the case to the 8th Circuit Court of Appeals, which initially sided with the federal government's interpretation. The appeals court ruled that SAPA obstructed federal enforcement in ways that violated constitutional supremacy. The DOJ hoped the Supreme Court would uphold this ruling and set a precedent, killing SAPA-style laws nationwide before they could spread to other states. Instead, the Supreme Court delivered an 8-1 ruling that gutted the DOJ's central legal argument. The decision appears technical on its surface, but the legal implications are massive. The court effectively said the DOJ's challenge lacked the kind of concrete harm required to justify federal intrusion into state policy. Without proven harm, actual, demonstrable obstruction of federal law enforcement, the federal government cannot override Missouri's choice about how to allocate its own state resources. The court denied the DOJ's emergency application to block SAPA, saying there was insufficient evidence of harm. justices reaffirmed that states retain the right to withhold cooperation in federal enforcement efforts. The anti-commandeering doctrine was upheld without needing a full review of SAPA's merits, and only Justice Sotomayor dissented, warning that the law could lead to enforcement chaos. This ruling wasn't a full endorsement of SAPA.
This case could reshape how far states can restrict your right to carry.
This is a case that's been bounced around back and forth throughout the court system.
John, St. Louis County, and Jackson County say the law is unconstitutional, and one of their arguments is how it impacts the cooperation between local and federal authorities.
That's unconstitutional.
Second Amendment Preservation Act is misnamed. It should be the Separation of Powers Destruction Act.
Many law enforcement officers oppose the controversial law, but the state's top cop vows to keep fighting for it.
The federal government cares about this case because this law has posed substantial threats to public safety. Because of HB 85, it has become harder for us to investigate all manner of crime, including violent crime, in this state.
The court didn't declare the law completely constitutional or rule on every aspect of its implementation, but what the court did do was reject the DOJ's framing of the case and block the federal government's attempt to shut down state resistance to gun control enforcement. That matters enormously because the DOJ wasn't just trying to win against Missouri, they were trying to create a broad precedent that would prevent other states from passing similar laws. By choosing to challenge SAPA early and aggressively, the Department of Justice hoped to establish clear boundaries before the movement could spread. That strategy just backfired spectacularly. Without a ruling declaring SAPA unconstitutional, the legal ground remains open for other states to follow Missouri's lead. And they're already doing exactly that. SAPA-style bills are appearing in state legislatures across the country. Texas, Arkansas, and Arizona have introduced similar firearm sovereignty laws. Florida, Oklahoma, and South Carolina lawmakers are drafting SAPA-modeled legislation. Several state attorneys general have publicly voiced support for Missouri's legal strategy. The Supreme Court's ruling just gave political cover for hesitant lawmakers to act boldly. The ripple effect is undeniable. With federal challenges now paused, more state governments are stepping forward to protect gun rights through their own enforcement shields. Missouri may have been the test case, but it won't remain the only case for long. What does this mean for federal agencies operating on the ground? The Supreme Court's decision doesn't strike down any federal gun laws. Federal regulations on firearms remain valid nationwide, but the ruling makes one thing crystal clear. The federal government cannot use state and local officers as its foot soldiers in enforcement efforts. That leaves agencies like the ATF and FBI in a difficult operational position, especially in SAPA states. Federal agents must now conduct investigations, execute raids, and enforce compliance efforts without assistance from local or state law enforcement. Missouri police officers face potential fines or lawsuits if they help federal agents enforce certain gun regulations. The federal workload increases dramatically while local collaboration disappears. This breakdown in cooperation may stall gun enforcement efforts altogether, particularly in rural areas where federal staffing is already thin. When the ATF wants to investigate a firearms dealer in rural Missouri, they can no longer simply call the county sheriff for backup or information. They must dedicate their own limited federal resources to every aspect of the operation. For states considering SAPA adoption, this creates an interesting calculation. The laws don't prevent federal enforcement, they just make it much harder and more expensive. Federal agencies have finite resources, limited personnel, and budget constraints. If they must handle every aspect of gun enforcement independently in SAPA states, those constraints become binding much faster. Can the federal government retaliate against SAPA states after this ruling? Many are asking what the Biden administration can do to push back. The answer is complicated and carries significant risk for the federal government. The federal government could theoretically withhold certain discretionary funding from SAPA states, but that risks triggering new lawsuits under constitutional spending clause limitations. Congress could attempt to pass legislation explicitly countering SAPA laws, but political support for such measures is unlikely given current congressional composition. The DOJ may pivot to bringing civil enforcement actions against individuals rather than challenging state laws directly, but that's resource intensive and doesn't address the underlying cooperation problem. Any aggressive federal response now risks triggering another Supreme Court battle, one the DOJ just demonstrated it's not guaranteed to win. Every move will be closely watched by states considering their own versions of SAPA. One federal overreach could galvanize the movement rather than contain it. For gun owners in states without SAPA protections, this ruling still matters profoundly. It signals that the Supreme Court supports state-level resistance to unconstitutional enforcement. That means voters, sheriffs, and lawmakers in your state now have a new legal argument and a new political opportunity. Gun rights organizations are already using Missouri's victory to campaign for SAPA laws in other states. Some county-level officials are declaring themselves Second Amendment sanctuaries even without formal state legislation. Sheriffs may refuse to enforce new federal restrictions based on their own reading of constitutional limits. State elections may now center around Second Amendment enforcement pledges as candidates compete to position themselves as protectors of gun rights. This ruling provides political fuel to grassroots Second Amendment efforts in every state, and it raises a critical question. What happens if 10 or 20 states adopt similar laws? At what point does state resistance become so widespread that federal gun regulation becomes effectively unenforceable in large portions of the country? The battle is far from over. The Supreme Court's 8-1 ruling was powerful, but it addressed only the emergency motion to block SAPA, not the merits of the law itself. Future lawsuits could still reach the court, especially if enforcement conflicts arise that demonstrate actual harm to federal operations. Missouri won this round, but the next phase could be even more consequential. The ruling denied emergency relief but didn't address whether SAPA is fully constitutional in all its applications. Federal agencies may bring new challenges if they can demonstrate concrete obstruction. If other states pass even stronger SAPA laws, those could face challenges in different circuit courts with potentially different outcomes. Future litigation could force the court to define the limits of anti-commandeering more precisely. We're entering a new chapter of Second Amendment litigation where the battlefield has fundamentally shifted. For decades, gun rights battles focused on which regulations the federal government could impose. Now, the question is whether states must help implement those regulations, even when they believe them unconstitutional. The Supreme Court just told the federal government that states retain sovereignty over their own resources and personnel. The DOJ didn't just lose a case, it lost its entire strategy for preventing state resistance before it could spread, and now that strategy is spreading rapidly. Every gun owner in America needs to understand what just happened. This wasn't just about Missouri, it was a statement that federal power has limits and that state sovereignty still means something in modern America. The real battle is only beginning as more states step forward and Washington must recalibrate its entire enforcement approach. That's it for today, folks. See you in the next video.